As you are aware, a dispute arose on who has the decision to draft a judge. Justice Murima made it very clear that the charge sheet can only be drafted and presented to court by the DPP. Agreed with that decision, the Inspector General of Police went to the Court of Appeal and convinced the Court of Appeal, and those orders were stayed. And the import of that is that the police charge sheet is the one to be utilized. Surprisingly, from nowhere, the Law Society of Kenya's president issues a circular, a letter to all advocates, me in particular, that I should not comply with the judgment of the Court of Appeal. I should reject any charge sheet drafted by the police. I should not comply with the stay orders of the Court of Appeal. I have written serious letter questioning the following. Where was LSK when this matter was in the lower court, the High Court, and in the Court of Appeal? Under Section 4 of the Advocates Act, the role of LSK is to defend the public interest. A charge sheet, a national security question, is a public interest. LSK leadership took cover. They never participated in the proceedings. 2, who stopped LSK from making an application for joinder at the Court of Appeal so that their voice is heard? Nobody. It is basic knowledge to everybody that if you are aggrieved with the Court of Appeal decision, you do not give outside directives. You go to that Court of Appeal, apply to be enjoined, seek for review, seek for variation, seek for stay, so that the Court of Appeal stays. 3rd, the directions issued through that letter by the President of LSK, is LSK now a Supreme Court that can overrule, can overturn the decision that the Court of Appeal has made? So I am aggrieved whether I should comply to a letter from the LSK Council, or I should comply with the decision from the Supreme Court or the Court of Appeal. Remember, LSK has confirmed that they are siding with the DPP. If they are in agreement with the DPP, they were to file their application, their pleadings in support of the DPP. They have no business writing to tell the DCI, tell the DPP on how to function. They can only litigate under the public interest. So I have demanded by that letter that we need to know whether the failure of the LSK to pronounce itself on matters national interest, is it a council that is moribund, that cannot be able to defend the interests of the advocates? In the matter that we have filed, for example, we have raised the question that the chairman of the LSK, the president of LSK, sits in the ODPP advisory board. He's a member of the ODPP advisory board. Clearly, there is serious conflict of interest between the president of LSK and the ODPP in an attack on a judgment of this Court of Appeal. Lastly, in the office of the ODPP, the issues we have raised about staff, chairman and the council has never responded, one, on the massive chasing of state councils from the office of the DPP deployed to departments of government who defends those advocates in the office of the DPP who have been chased, who are not being promoted properly, who are not being recruited in a transparent manner. Reason is because the office, the President of the Law Society of Kenya, is completely conflicted. Lastly, the letter we have demanded is signed by the President. Did he have the mandate of the full council? We are demanding for the signatures, the council members who sat to arrive at that decision. Did the council members, if they ever sat, why did they not append their signatures on that letter, that directive? Lastly, did they participate? Did they allow us as advocates to participate in that matter? And that is why we have said those directions are sub judice. Those directions are contemptuous to the Court of Appeal decision, and we want accountability from the office of the President of the Law Society of Kenya, and that is why we've done that. My good friend can comment on it.
Maybe Okili ones are presented in court without the consent of the DPP.
That is what you are fighting.
Even before the DCI used to, they have to get the consent of the DPP before they come.
The Court of Appeal has pronounced itself. It is no longer a question of interpretation by me, by my President Eric Theuri, by Nurdin Haji, or by Kinoti. It is a Court of Appeal interpretation that the status quo returns. The status quo has returned.
And the status quo meant police.
The police.
The consent of the DPP presented.
The police under Section 137 provides the drafting of the charge sheet. The magistrate under Section 89 accepts the charge sheet. That is currently the position of the law.
We can present even without the consent of the DPP.
The Court of Appeal decision has not recognized the DPP as having any role. I don't want to move to give my own interpretation. The position as it is, the DPP's position is to take over the matter after the charge sheet has been admitted by the court, by the magistrate under Section 89.
President Mr. Eric Theuri holds is an office that is donated by the LSK Act, and his objectives are purely to ensure that we promote constitutionalism and the rule of law. And the rule of law to this extent means that when court orders are made, and more specifically speaking about the Court of Appeal making its orders, staying the previous directions or orders that were made by Justice Mrima, restraining police officers from signing, presenting, or otherwise drafting charge sheets. This is to mean that the mandate of my president, Mr. Eric Theuri, is limited towards educating or encouraging members of the bar or the Law Society of Kenya to ensure that they strictly circumscribe and respect the decision, or rather the interim orders that were issued by the Court of Appeal. Now, this is to say that in the statement communicated and dated the 24th day of June 2022, where my president, Mr. Eric Theuri, has directed or has advised members of the bar to protest against charge sheets presented, signed, or filed before court by a police officer. To that extent, we find that that position or that advisement or that advice by the president does not sit well within his mandate as the president of the Law Society of Kenya. This is to mean that what we had hoped to see from him is the president telling us that we need to, at first, respect the orders of the Court of Appeal, regardless of how improper or how unconstitutional we might think for now they appear. The law, as we know of it, advises us that even while you find orders issued by a court to be improper, to be unconstitutional or otherwise, you must respect them unless and until they are set aside, they are vacated, or they are appealed by a superior court. So to that extent, we find fault in that, and we are encouraging the president to withdraw that letter of the 24th day of June 2022, because in other words, he is encouraging us, members of the bar, to act contemptuously to the authority of the Court of Appeal. Remember, if you were to look at the hierarchy of courts, Justice Mrima, Anthony Mrima, who sits at the High Court, sits lower in rank than the judges of the Court of Appeal. So if we are torn between which orders to obey, that of the High Court or that of the Court of Appeal, we must, and I say this so respectfully, we must respect, obey, and adhere to the orders that are made by the Court of Appeal. And I'm hoping that responds directly to the question that my good friend has asked my boss and my senior. Thank you.